In Roach and Matthews versus Home Office, the High Court, presided over by Mr. Justice Davis, with Assessors Master Wright and Mr. Robert Carter, determined the recoverability of inquest attendance costs in subsequent civil proceedings. The appeals concerned two cases where claimants, following inquests into deaths in custody, settled civil claims against the Home Office. The central issue was whether such costs were of and incidental to the civil proceedings under Section 51 of the Supreme Court Act 1981 and governed by the reasonableness and proportionality tests in Rule 44.4. The Home Office argued an absolute rule that costs of one proceeding could never be incidental to another, citing Wright v. Bennett and Aden Shipping Company Limited v. Interbulk Limited. The court rejected this, finding no such jurisdictional bar in the statute's wide discretion. It approved the principled approach from Re Gibson Settlement Trusts and the Bowbell, holding recoverability depends on whether costs were of use and service in the action, relevant to an issue, or attributable to the paying party's conduct. The court dismissed the Home Office's appeal in Matthews and its cross-appeal in Roach, upholding that inquest costs were, in principle, recoverable. It allowed the claimant's appeal in Roach, finding Master Hurst's 50-50 cost division, based on a dual purpose, flawed, and remitted the assessment for reconsideration of relevance and proportionality. The legal aid funding for the inquests was deemed irrelevant to the principle of recoverability. Quote, "I therefore find that the approach taken by Justice Clark in the Bowbell was correct. Costs of attendance at an inquest are not incapable of being recoverable as costs incidental to subsequent civil proceedings. Nor does this give rise to any unprincipled approach, because the relevant principles, as conveniently set out in Gibson, are available to be applied by costs judges in a way appropriate to the circumstances of each case."